Good morning, good afternoon, I think, for many participants. My name is Ann Wicks. I'm assuming we're going to have a few people that are going to be dialing in as we get started here. I am welcoming everybody. Just a little bit of background. So this is a COVID-19 update, and it's going to cover two primary aspects that employers are dealing with during the coronavirus crisis. The first is the emergency leave laws and some of the changes to OSHA safety regulations that are impacting businesses. And the second half is more around things to think about when reopening or pivoting in your business to address if you've been working at limited capacity or in other ways, things to think about as you reopen in order to not only be viable financially, but also to take the safety precautions and things that you need to take. Little introduction for myself. My name is Ann Wicks. I am an attorney. I am located in California. I have been practicing employment law for about 25 or more years. I started out at Littler Mendelson, which is a national law firm that does only management side employment and labor law. I was a partner there. I was a litigator there for many, many years. And then I left Littler. I went to another firm called Cooley Goddard, which is also in San Francisco and Palo Alto. It's a national law firm where I worked with a lot of startups and tech companies and venture capitalists and things of that nature. And I've had my own practice now for about 15 years. I represent both employers and executives with all aspects of their employment, not including ERISA law, workers' comp law, and high-level tax law. I am a California-based attorney, and as a California-based attorney, I need to know both the federal laws that apply to employers as well as the California-specific laws. For this particular presentation, I am focusing on the federal laws that have been put into place, as well as just practical considerations for employers. As a little background, the date on the first slide is obviously wrong. It's not April 13th. So I obviously did not update that particular slide. But as a little bit of background, I have been doing a COVID-19 update weekly since the beginning, or I should say the mid-March timeframe for employers in California. And so this presentation that I'm doing now is a customization of a prior training that I had done for the Monument Builders of North America. And I would like to thank Paradise Pictures, our sponsor for this session, and I would like to welcome everybody who's here. As just sort of a note in the beginning, I tend to answer questions as I go through a presentation because the information that I'm presenting to you can be complex. Sometimes people have questions about something I've said. And if you do have a question, I would ask that you put it in the chat bar, and I will ask Chip or Charlene, our moderators, to let me know that there's a question, and I will answer it as soon as I am aware of it. So with that, I am going to go ahead and begin. Okay, so we are scheduled to have a 90-minute session. I will do my best to stay on time. There's a lot of information to present. And just so you know, after the presentation is over, you will be receiving an email with some handouts. And those handouts will include the slide deck that you are going to be seeing as we go through the presentation. There is the workplace poster that needs to be posted in all workplaces regarding the family-friendly COVID Coronavirus Relief Act. There are some guidance from federal OSHA on when to report illnesses or injuries, particularly those related to COVID-19, 10 steps that all employers can take for workplaces to be safe. This is another poster that OSHA has put together, some EEOC guidelines around ADA issues that also impact COVID or are impacted by COVID-19, as well as some COVID-19 guidance. So you will be getting all of those via an email. Today, we're going to talk about the benefits under the Family-Friendly or Family First Coronavirus Relief Act, also known as the Emergency Paid FMLA and Emergency Paid Sick Leave provisions. I will go through those different provisions in detail, along with explaining the hardship exemption, some of the most common questions that I've been receiving over the last 6 or 8 weeks, as well as some mistakes that employers have been making during work furloughs, just to alert you to the fact that there are some traps for the unwary in there. I would be talking about workplace safety, reopening America. And I do want to point out that the purpose of this webinar is to help educate you about your requirements as an employer. It is not intended to be legal advice. So if you have specific situations that you are addressing, I would encourage you to seek out your legal counsel, your HR department if you have one. There's a lot of government guidance out there, which I'm going to be showing you how to find, just to make sure that you are in compliance. The other thing I want to mention is that this session is being recorded. And so if we do take questions by video or by phone, they will be recorded as well. And so by speaking up, you are consenting to being recorded. So I don't want anybody to be surprised by that. Okay, so let's get started. Beginning at the end of March, we had the first emergency bill passed around aid for workers in response to the COVID-19 crisis. It's called the Family First COVID-19 Emergency Relief Act, and it has two components to it. It has an FMLA component to it, and it has a sick leave component to it. And both of those components involve paid leave for employees who are impacted by coronavirus. And essentially what employers are required to do is any employer who's a private employer with less than 500 employees has to provide paid sick leave and paid emergency FMLA under specific circumstances. So we're going to talk about the FMLA provisions first. In other words, the Family Medical Leave Act provisions. So that particular portion of the bill went into effect on April 1st and is effective only until December 31st, at which point it expires unless it is extended by Congress and the House. It applies to any employer with fewer than 500 employees, including employers who used to have more than 500 employees, but through layoffs or attrition or what have you, have dropped down to less than 500. In order to know how many employees you have, many employers are smaller employers and they know that they have less than 500 employees. But for those that are in the middle and aren't sure, you should count all employees who work for you, whether they're on leave, temporary employees, day laborers, part-time, full-time, joint employees if you use staffing agencies, essentially anybody who is an employee except for an independent contractor. And you would count the number of employees that you have on the day that the leave would begin for somebody who is requesting leave to know whether or not this law applies to you. The only purpose for this emergency FMLA leave is to care for children under the age of 18 if their school or place of care has been closed. And that includes if that school has moved solely to online classes, or if their child care provider is unavailable due to COVID-19 related reasons. It also applies to any employees who have adult children over the age of 18 with physical or mental disabilities, and they are unable to provide self-care. So if they normally have a place that they would go, and that place is closed, you would also be eligible for leave under this provision. The leave is only available when it is needed to care for the employee's child, and the employee is actually the person providing the care and unable to work or telework because of that care. If a co-parent or a co-guardian or their usual care provider is available, then the employee is not eligible for the leave. And the statute defines who is a son or daughter, who is a child, as your own child, a biological, adopted, or foster child, stepchild, anyone essentially who you stand in loco parentis, which is Latin meaning, you stand in the place of the parent, somebody who has the day-to-day responsibilities for providing financially or physically care for that child. So that's who's eligible to take the leave. That's who a son or daughter is under the statute. And what the leave entitles you to is, it applies, first of all, let me back up. It does apply to any employee who has been employed by you for at least 30 calendar days. It doesn't mean they have to have actively worked for those 30 days. It simply means that they have to have been on your payroll for 30 days. And they are eligible to get up to 12 weeks of paid leave, although the first 2 weeks of that leave is unpaid. but you can substitute emergency paid sick leave under the same bill if they qualify, or other accrued unused vacation, paid time off, or sick leave that they have available to them through your business. So what are the 12 weeks of benefits that are available? Well, as I said, it's up to 12 work weeks of paid leave. The first 10 days of that, or 2 weeks, is unpaid. And the way that you determine how somebody gets paid is you pay them an amount not less than 2/3 of their regular rate of pay at the number of hours they would regularly be scheduled to work, not to exceed $200 a day or $10,000 in the aggregate. And I should point out that 2/3 of the regular rate of pay or 2/3 of minimum wage, whichever is greater, is how the statute reads. So if you have somebody who's making more than minimum wage, you can't drop them down to minimum wage and then pay them 2/3 of that. You have to pay them 2/3 of their regular rate. Now, the other wrinkle to this particular statute is that if an employee's hours have been reduced because you just don't have as many hours available, maybe you're not as busy, or you have a reduced schedule in order to address what's happening in the world, the only amount that the employee would be paid is the amount that they would have been scheduled to work if they had not taken leave. So if somebody is out on a furlough, or you're just saying, we're not working this week, we're shut down this week, then there's no pay for the person who is taking that leave, essentially because they're not scheduled to work. And so it actually would end up being an intermittent type leave situation, potentially, because there's no work scheduled. So are there any questions so far? I just want to make sure that everybody is following along.
Yeah, I don't see any in the chat box, Ann.
Okay, great. Thank you. Just wanted to check in. Okay. So how do you determine what to pay employees who may not work a regular, predictable schedule? What we call variable hours employees. Well, the amount that you pay the employee, there's a couple of ways that you can calculate it. What you're supposed to do is you're supposed to do a look back period, where if their schedule varies from week to week, you look back for the 6-month period that ends on the date the employee wants to take leave, and you average out the number of hours they are scheduled per day over that 6-month period to determine how many hours you're supposed to pay them while they are off on the leave. If the employee did not work for a 6-month period, and there's a reasonable period of time there in which you can perform that calculation, then you should use that period of time. However, if there's just no history there, perhaps it's a new employee who's been working for you for 30 days, then you look at what the reasonable expectation of the employee was at the time of hiring as to the number of hours a day the employee was going to be scheduled to work. The other thing that you have to do is you also have to look at how your operations have changed. And if your operations have changed such that, the variable hours employees and the full-time employees are all getting reduced hours, then you can pay out based on what the projected hours would have been had the person not taken leave. It has the same $200 a day limit. It's still paid out at 2/3 of the regular rate or 2/3 of the minimum wage, whichever is greater. And the $10,000 aggregate limit applies, meaning for the entire 12-week period of leave, they do not receive more than $10,000 for the FMLA portion of that paid leave. So it's really the 10-week period where the $10,000 aggregate limit applies, because of course the first 2 weeks are unpaid under the FMLA portion of the leave. The way that employers are reimbursed for this, there are actually 2 ways. The primary way is that employers receive a tax credit from the federal withholdings that they would typically make when they submit their quarterly tax payments for withholding federal taxes, etc. So it's an offset, it's a credit for what you would pay. There is also a process that you can follow if that is not sufficient to cover your losses, to provide for emergency relief, emergency funds to be paid to you to cover the emergency leaves. And what I would encourage you to do is look at the provisions for how to go about doing that and seek some advice from a tax attorney or your CPA or your regular bookkeeper on how to go about doing that. I am not a tax attorney. I cannot provide tax advice. But I do know that that is how the law is scheduled to reimburse employers. Okay. So some of the things that come up, and I'm just, hopefully I won't mess up my screen. I'm trying to move some of the pictures of people, attendees, off to the side so I can see my screen. If an employee has already taken some FMLA in the last 12 months, the emergency FMLA leave benefit will be reduced by the number of days or weeks that are already taken. So for example, if you have somebody who went out because they were having surgery or they were pregnant and they had their baby and they took leave in January or February, whatever amount of leave that they have taken comes out of that 12 weeks that is available under the emergency FMLA provision. And that's because this is an amendment to the Family Medical Leave Act. It's not in addition to. What it has done is it has created a new leave right for that employers with fewer than 500 employees are required to give. And it's only there for a limited period of time, but it has not extended the total amount of FMLA that's available. The other thing it has not done is it has, even though these particular emergency paid leave provisions apply to employers with fewer than 500 employees, if you are a larger employer, you still have a requirement to provide unpaid leave under the FMLA for anything that is non-COVID related. And if you are an employer that has 50 or more employees within 75 miles, and you have an employee who's worked at least 1,250 hours in the last 12 months, you still have a requirement to provide unpaid FMLA for other health-related reasons that are not COVID-19 related. So it does not replace the unpaid FMLA leave. It is not in addition to it. It is really, it can run concurrent to, and it just requires that you as an employer understand that this is an additional reason why somebody can take leave. And if you have fewer than 500 employees, then it has to be paid leave. It also does not impact eligibility, the prior use of any FMLA. Let's say you have somebody who's already exhausted their FMLA for the year. It does not impact their eligibility for the paid sick leave portion of this bill. So for those of you who have FMLA and somebody has taken their 12 weeks of FMLA in the last 12 months so that they have exhausted it, they still get that 2 weeks of paid sick leave if they're eligible under this bill. So hopefully that makes sense to everybody. Okay. With this emergency FMLA amendment, there are job restoration rights. If you are an employer that has 25 or fewer employees, you need to restore the employee to his or her position if it is available. But if the job is no longer available because, for example, you have gone through layoffs and eliminated positions in response to COVID-19 related economic conditions, then you do not have to restore the employee to his or her position. However, if you are an employer with 26 or more employees, you must try to restore the person to their job with a few exceptions. If somebody is a highly compensated key employee, you need not restore them to their job, but you should provide them with advance notice when they take the leave that their job will not be waiting for them when they return, in accordance with the regular guidelines of the FMLA. There is no greater right to reinstatement than those who did not take leave. In other words, just as employers with fewer than 25 employees don't have to restore somebody to a job if it is eliminated due to layoffs, neither do you if you have 26 or more employees. However, if the job is not available, you must make a reasonable effort to restore the employee to an equivalent position to the one that the employee held when their leave started. An equivalent is looked at as the same pay, benefits, and terms of conditions of employment. Well, what if you don't have an equivalent position available? Well, then if you have 26 or more employees, you have to watch your openings for the next year, and you must offer any job openings that become available that are equivalent to somebody who took the leave and who lost their job because it was no longer available. In other words, you have a 1-year period in which you have to try to restore that person to a position, an equivalent position within your company following the expiration of their leave. And that only applies to employers that have 26 or more employees. So that is the emergency FMLA provision. And now I'm going to move on to the emergency sick leave positions. And Chip, if anybody does have any questions that come through, just feel free to speak up and interrupt me. Okay, so the emergency sick leave provisions, part of the same bill. Again, it applies to all private employers who have had at least one employee for 20 or more weeks. So there's a difference in how you qualify for the leave. For the emergency FMLA, if you have an employee, even if you only have one employee and they have worked for you for at least 30 days, then that employee is eligible to take leave. Under the emergency sick leave, there is no time requirement for the employee. Instead, if you are a private employer and you've had at least one employee for 20 or more weeks, and you have fewer than 500 employees, then the emergency sick leave provisions apply to you as an employer, and you are required to provide emergency paid sick leave to employees who qualify for that leave. It also applies to certain non-private employers, in other words, certain local, state, and county government employers. And there is a joint employer test that's usually beyond what anybody in these seminars needs, so I'm not going to go into that. And there are some exceptions, both under the emergency FMLA and the emergency sick leave, for employers who are healthcare providers or emergency responders who can elect to exclude their employees from application of these provisions. And what I mean by that is hospitals and first responders, police, fire, emergency workers, if they provide everybody leave, may not have enough staff in order to fulfill their functions. And so they can choose to not provide the leave to workers if they fall within the definitions of emergency workers. And there are definitions in the statute. If you are a provider or an employer who has some emergency responders or healthcare providers who work with you, there are definitions. Given the focused nature of this association, I doubt that that is the case, so I'm not going to focus on that, and I think I actually took the definitions out of what an emergency responder is. So just so you know that. So the purpose of the paid sick leave is to provide paid sick time for an employee who is unable to work or telework due to a COVID-19 related reason. So there are 6 reasons for why somebody can take paid sick leave. The first 3 reasons are all individual employee reasons. The employee themselves is impacted by COVID-19 related concerns. So reason number 1 is they have been subject to a quarantine or isolation order from a local, state, or federal government. Reason number 2 is they have been advised by a healthcare provider to self-quarantine due to COVID-19 related concerns. And reason number 3 is that they are experiencing COVID-19 symptoms and seeking a diagnosis. It is really important for reason number 3 that the employee be seeking a diagnosis, or else they aren't eligible for the paid sick leave. Reasons 1 through 3 are paid out, as you will see in the next slide, at the employee's regular rate of pay during the time period in which they are off for up to a total of 80 hours. Reasons 4 through 6 are really related to the employee caring for somebody else who is subject to a quarantine or isolation order, or who has been advised to self-quarantine, or an employee who is caring for a child whose school or place of care has been closed because of COVID-19 precautions. So remember that first 2 weeks that's unpaid under the FMLA, emergency FMLA provisions. This qualifies somebody to get 2 weeks of the paid sick leave under reason 5. And then reason 6 is that the employee is experiencing any other substantially similar conditions specified by the Secretary of Health and Human Services in consultation with the Secretary of Treasury and Labor. Now, reason number 6 has not had any additional conditions specified yet. It's a placeholder. I suspect that some of the things that we are seeing with children in particular may be identified as COVID-19, or they may fall within this number 6. But until that happens, it's really reasons 4 and 5 are where somebody is caring for somebody else. There is a cap on the amount of paid sick leave that's available. It's up to $511 a day, or $5,110 in the aggregate for reasons 1 through 3. And it's $200 a day, or $2,000 in the aggregate for reasons 4 through 6. Again, reasons 1 through 3, it's up to 80 hours if you're full-time. And then if you're part-time, it is based on the number of hours you would have worked, just as it was for the FMLA. But the pay must be provided at the employee's regular rate of pay or the minimum wage, whichever is greater, for reasons 1 through 3. For reasons 4 through 6 is $200 a day or $2,000 in the aggregate, which must be paid out at 2/3 of the employee's regular rate of pay or 2/3 of the minimum wage, 2/3 of the minimum wage, pardon me, whichever is greater. And again, that is what I just said about the number of hours that are available. It's important to note that the paid sick leave does not carry over from 1 year to the next, which makes sense because this law does expire on December 31st. Paid sick time is not required to be paid out upon separation from employment. Some states require when an employee gets PTO or vacation that it be paid out on termination. California is one of those states. There are other states that do not require that. So the requirements in terms of what you pay out on termination and what you don't are going to be specific to your state. But this law makes it clear that the paid sick time is not something that you have to pay out. And then, of course, there is no retaliation allowed. So an employer can't discharge or discipline somebody or discriminate against an employee who takes COVID-19 paid sick leave or files a complaint under the Act or testifies in a proceeding on behalf of somebody else who has filed a complaint that they were improperly denied use of paid sick leave or paid FMLA for that matter. Okay, so when is a person eligible for paid sick leave as a result of self-quarantine? Because some people are self-quarantining. Well, if a healthcare provider believes you have COVID-19, are particularly vulnerable to COVID-19 and is quarantining you, then you're eligible for paid sick leave. If you're ill with COVID-19 symptoms and you're seeking a medical diagnosis and you've been told to quarantine in the interim, then you're eligible for it. But if you're not seeking treatment or a diagnosis, you are not eligible for the leave, even if they're ill with COVID-19 symptoms. So it's important for your employees to understand that if they want to receive the paid sick leave, that they're going to have to see a doctor or a medical professional who's going to be able to give them a diagnosis. Another question that came up, especially early in when this law first came out, is when is an employee eligible to take paid sick leave to care for somebody else, especially if that somebody else may not live in their household? Well, they're eligible to take the leave if the individual that they're caring for is unable to care for him or herself and depends on that employee for care. So, for example, parents, you may have some elderly parents who rely on you for care, who live close by, and that care prevents the employee from working or teleworking. Or if the individual genuinely needs the employee's care, including somebody who resides in their home, or their relationship creates an expectation that the employee would care for that person while they're quarantined or self-quarantined. And again, the employee cannot work or telework due to providing that care. But it does not apply to somebody with whom they don't have the type of relationship where you would expect that. So sometimes, I think the ambiguity here is, what about an elderly neighbor? What if I have an elderly neighbor that I run to the store for every week and get groceries? I come over, I help them with some personal care things. I do it out of the goodness of my heart. And this person now is in quarantine and needs some assistance. Does that qualify? Well, if the relationship creates an expectation that you would be the person to care for them, then I would say that you would qualify. But if it's somebody that you don't have that kind of relationship with, and you've just learned that your neighbor across the street is sick and may need some help, but you're not the person that would normally be expected to step up, then you're not going to qualify. So there's a little bit of judgment involved here. It's one of those things where most employers are providing for leave for people who are trying to be compassionate when they can. People are pulling together and trying to do the right thing here. When an individual, the final one is when an individual is self-quarantining on the advice of a healthcare provider, and that person requires the employee to provide the care that prevents that employee from working or teleworking. I may have already said that, but it goes without saying, if the employee can work remotely, they're not eligible for the leave. So now that we know all of the reasons for leave, the next question that inevitably was asked was, well, how do I know that this person is really qualifying for these leaves? Can I get a doctor's note? Can I request that they provide me with information? when the bill first came out, we didn't have the answers. Now we have some of the answers, but not all of the answers. Some regulations were put into place to explain the bill. There were a number of FAQs and employer guidelines and things that were put out. I'm going to walk you through the website in a few slides in a little while to show you where to find some of the information so that you can look at that yourself. But according to the Department of Labor, which is the branch of the government which is responsible for administering and following up on claims under the FMLA and the paid sick leave provisions, this is the type of documentation that you can seek. If somebody is quarantining due to a government order, then you can ask for the name of the government entity that issued the order and even a copy of the order if that is the basis for the person taking the leave. If a person is taking leave due to a health-related condition, either their own or somebody else's, where they're caring for somebody, you can ask for the name of the healthcare provider who advised the employee or the individual that they're caring for to self-quarantine. And I would get the name of the doctor or healthcare professional, the facility that they are associated with, the contact information, just so you can do a spot check to make sure that it's legit. You may not be able to get any information. You can't call and say, did you advise this person? But you can look up to see if this doctor exists. You can also get the name of the government entity or healthcare provider that told the individual or the person that they're caring for to self-quarantine. In other words, if the local health department told you to self-quarantine, you can figure out who's the name of the person at the health department, and what's the official name of the health department that gave that person the information. And then when it comes to caring for children or somebody who can't care for themselves because their school is closed or their place of care is closed, you can get the name of the child. You can get the name of the school district or the provider that is closed. I would ask for any notification that the employee received from that provider. And you can ask the employee to provide a representation to you that there's no other suitable person who will be caring for the child during the time period that the employee is to be on leave. And this comes up because of spouses. If there are two spouses who are home, the question becomes, who's caring for the child? Is it you? Is it your spouse? And it may be that they are splitting the duties, that one parent takes the morning shift, one takes the afternoon shift. And again, the reason for the leave is that the employee cannot come in because they have to care for the child, or they can't telework because they're caring for the child. And so there may be some follow-up questions and things that you can ask. The other thing is that you can request any documentation that supports the tax credits that you're going to receive, but there really hasn't been further guidance on this, although I saw an alert come across my screen just this morning saying the IRS put out some guidance on something related to COVID-19. I'm not sure if it's the CARES Act or the PPP loans, or if it's this guidance on the tax credits, but I did see an alert that something was issued this morning or maybe yesterday. I just haven't had a chance to look at that. In any event, the DOL confirms that there will be guidance from the IRS as to what type of documentation employers are going to have to submit to get the tax credit. But the best practice that I recommend to everyone is that you need to document the information that employees are giving you around leave, the employee name, the date the leave begins, who the doctor is that told them to isolate, how long they're going to be isolating. If you have somebody who's taking the paid sick leave, don't assume necessarily that they're going to need all 80 hours, figure out what's going on. They may need, 2 or 3 days while they are seeking a diagnosis, and then they get a test, and if it comes back negative, then they are cleared to return to work. So they may not be eligible for the full 80 hours. So it's something that you as an employer will need to keep on top of and that you will need to document. So what the guidance that the DOL is providing essentially around documentation says is, look, you can ask questions, but you can't get a doctor's note. It falls short of saying that you have the right to require a doctor's note from third parties or a note from any other type of third party. Now, I will say that there are people who have been off work, and it's your typical practice when somebody takes leave and you want certification that they are fit to return to work. You can require return to work authorization after an extended period of leave, but what the government has been asking us to do is not require documentation unless strictly necessary, particularly if you are in a region that has been hard hit by COVID-19 because the medical resources are spread thin. So this is the documentation you can require. I think as we move further into this situation, you will see additional guidance as to the documentation that you can seek, and it will become more normal to be able to get a doctor's note or some type of confirmation. And again, because I am talking in this particular webinar to people all over the US, you should also look to your local and state requirements. So for example, in California, employees have a right to medical privacy, and so employers are not able to ask employees specific questions about diagnosis and treatment and symptoms and things like that. With the COVID-19 situation, employers are limited to asking about specific COVID-19 symptoms, but not about any other issues that are going on with their employers. And so I would check with your state and your local government in terms of what you are and are not allowed to ask about. For the Family First COVID-19 emergency sick leave provisions, you can provide intermittent leave if both the employer and the employee agree. And this is both for the emergency FMLA, but not for the paid sick leave if it's for the employee who has their own COVID-19 related problems or they're caring for somebody with COVID-19. Note, it can be provided for somebody who's just doing the child care portion. But if they are caring for somebody who has COVID-19, the guidance basically says you want that person off because they've been exposed and you don't want to expose your workplace. Obviously, if people are able to telework, there are more generous arrangements that can be available. You can allow people to take leave in increments that would allow them to continue to work. And we're encouraging everybody to be flexible in this regard. If it's non-office work, then the emergency leave is only available for the intermittent FMLA leave. The other thing I would point out is if there are workplace closures that are temporary or permanent, furloughs, employees, etc. Again, employees don't get paid during that time period. And if there are businesses that have been closed, such as restaurants, etc., then those closures will prevent somebody from getting paid during these leave periods. In other words, they don't even need to take leave because they're off work right now. Okay. Any employee may use emergency paid sick leave time before the FMLA. The employer cannot require them to use other paid leave that the employer provides. So this means, for example, in California, we have paid sick leave. Many other jurisdictions do as well. You cannot prioritize your state's paid sick leave or the paid sick leave bank that they have with you as an employee over the emergency paid sick leave. Although some employees will want to use that first. And employees can opt to use paid sick leave, paid vacation, other paid time off. The other thing that's required is that employers are required to post a notice that has been approved by the Secretary of Labor in their workplace, in the same place that you would typically have your workplace postings. The Secretary of Labor has issued a model notice. It is one of the handouts that is going to be emailed to you. The only one that I pulled from the website was in English. If you have a workforce that speaks other languages, there are other posters in foreign languages available, including Spanish and a number of common languages. So you can pull that off the DOL website. If you have employees that are working remotely, I recommend that you email a copy of the poster to them. It's downloadable. In fact, you're getting a copy of it as a PDF, and you can simply send it out to your employees to show that you have notified them of their rights to take emergency sick leave and emergency FMLA under these statutes, if these statutes apply to you. So just make sure you understand that. Okay. In terms of the practical considerations of paid FMLA and paid sick leave, sort of the nuts and bolts of working with these laws. First and foremost, determine if this law applies to you. How many employees do you have? Are they full and part-time? Do you fall within the provisions, taking into account layoffs, et cetera? Identify what it's going to cost you to provide the leave and determine whether or not you're going to qualify for a hardship exemption. Well, what's a hardship exemption? I have some slides in here that will explain the hardship exemption, but essentially, if you are a business with 50 or fewer employees and providing paid leave under this law is likely to jeopardize your ability to run your business, either because it puts you in financial jeopardy or you don't have enough staff to continue your essential operations, you may be able to take the hardship exemption and refuse leave to somebody. If you are an employer with more than 50 employees, that hardship exemption is not going to be available for you. The other thing that you need to do is you need to prepare how you're going to track who takes the paid sick leave, how much money they are paid out under the paid sick leave and paid FMLA in order to claim your tax credit, as well as the documentation that you need to demonstrate that you're entitled to take that tax credit. The other thing you should do is you should anticipate workforce fluctuation. In other words, the supply demand of workers due to people taking sick or FMLA leave because their school or place of care is closed, and what your staffing needs are going to be as a result of that. Understand how all of these different leave requirements and time off programs are also going to work with your other types of programs that you normally employ. And most importantly, in my opinion, you need to train your staff, your managers in particular, on how to administer these leaves, how to answer questions regarding these leaves, make sure they understand what is required so they don't inadvertently deny somebody leave, and then you find yourself with an issue down the road because you didn't provide leave that employees were entitled to take. So remember I said I was going to tell you about the hardship exemption. Here we go. So there are 3 reasons why a small business is able to claim the hardship exemption. When the bill first came out, we thought that there was going to be an application process to the Department of Labor, but they quickly realized that that was untenable, that they didn't have enough staff to deal with that. And so they are allowing employers to self-certify that the hardship exemption applies to them. There are 3 reasons why an employer can claim the hardship exemption if they have 50 or fewer employees. First, it's the economic reason. Payment of paid sick or FMLA leave would result in the expenses and liabilities exceeding the available business revenues and cause the small business to cease operating at a minimal capacity. In other words, you're going to run out of money. It's going to jeopardize your ability to continue. That's the first reason. The second reason is that the absence of particular employees or all employees who are requesting paid leave would entail a substantial risk to your business in terms of your ability to operate, because they have either specialized skill or knowledge or responsibilities within your business. So for example, if your payroll person, if your only accounting person took the leave and you have nobody to fulfill that function, you wouldn't be able to pay people, you wouldn't be able to send out bills, you wouldn't be able to receive, you wouldn't be able to do banking, it might jeopardize your business. That might be a reason to deny leave. Now, I will point out, you don't want to deny sick leave to somebody who is sick with COVID-19 because you don't want to infect your workplace. It's common sense, but I've actually had a few employers who've had people ask that question. So I just thought I'd point that out. Then the third reason would be that there are not sufficient workers who are able, willing, and qualified who will be available at the time and place needed to perform the services or labor that you as a business provide, because you have too many people requesting paid leave, for example, and so you wouldn't be able to operate at minimal capacity. In other words, you don't have the staff to open your business. If you are a grocery store, or if you, obviously with what you guys do, if you have, orders that you need to fulfill and you provide leave, and, having the person out is going to prevent you from being able to fulfill orders, then you can deny the leave. So how do you know that you've self-certified? How do you know that you qualify for this hardship exemption? Well, there are some expectations from the government in terms of how you go about making that determination. First of all, you determine if you're qualified. Do you have fewer than 50 employees? Have they requested leave for a viable basis, either FMLA or sick leave because the child's school or place of care is closed, or they're ill? If you are an authorized officer of the business, an owner, a high-level manager, etc., somebody with the responsibility of running the business or who can make that determination has to sit down and actually figure out that you do qualify under at least one of the 3 conditions that were listed in the prior slide, that you qualify for the leave, to deny the leave. The other thing is that they are encouraging employers to work with employees to try to find a solution that works in order to help maintain the business and ensure employee safety. So for that key employee, the accountant, for example, that you need to do something, maybe you can provide leave for the majority of the time, but you can work out something where, they come in 1 day a week in order to do the essential functions that you need to keep running, but you're able to provide some leave to them as well in order for them to deal with what they have going on at home. There is no application process, but you had better be able to demonstrate that the need for the hardship exemption exists, because what they are requiring is that if somebody is denied the leave and they work for a business with fewer than 50 employees, the first stop is the Department of Labor to file a complaint that they were unfairly denied the leave, which will then put a Department of Labor investigator on the case who will reach out to you as an employer and say, I have a complaint against you. Are you claiming the hardship exemption? Where is your data demonstrating that you qualify for that exemption? If you qualify, then the case will be closed. I also would encourage you, if you are denying somebody leave based on the hardship exemption, that you let them know, look, we'd love to be able to provide you with the leave. We can't do it because of the hardship it creates for the business, and so we're denying it on that basis, and that may actually prevent an employee from going and filing a claim against you. The best practice for you as an employer is to make a case-by-case determination and analysis over time as to whether or not the hardship exemption applies to a particular request from leave, as opposed to saying, we're small, we can't afford it, we're just saying no to everybody. Because when you make that kind of a blanket determination, you may not have the documentation to back up that it really is a hardship for you. So you need to make sure that you can show it at the time that the leave was denied. So some examples of how to document your analysis justifying the exemption and how to maintain the records. If you have an employee who you're denying leave and they have a skill set that you need, then you should write a short paragraph or put some bullet points together as to what the employee's skill set are and how that will impact your operations or your ability to continue operating as a business. If it's financial, you can't afford it, then generate the financial models that show the expense to income ratio and the losses that jeopardize your ability to continue. If you can't maintain operations because you need so many workers per shift, then document the workflow and how many people you need in order to keep that workflow going. For example, I use a grocery store here or a retail outlet. If you need 1 delivery driver or 1 stocker for X volume of product and you get 10X volume per shift to move stock, then you need 10 workers per shift and you have 12 workers per shift available. So therefore, you can have 2 workers out per shift on leave. So, first come, first serve, make sure that if you have people that are requesting leave that you are administering it in a fair manner, but also be able to document, I can allow a couple of people to be out, but I can't allow everybody to be out. And here's why. If you have that kind of justification, it will help you later if your hardship exemption is challenged. As I indicated, there is a COVID-19, Family First COVID-19 Emergency Relief Act poster. It is in the stuff that is being emailed to you. Make sure you post it everywhere you typically post workplace notices, and that if you have people working remotely, that you send it out. So I'm going to shift gears a little bit. I'm going to show you how to find some of the resources that you may need in order to navigate some of these issues and find out information for yourself. There are a number of great government websites, and these government websites have all kinds of information for employers and employees on things that they need to know. So if you go to www.dol.gov, there is a link that says COVID-19 right at the beginning of the page. You click that link, it gets you here. And what you find on this is you find a number of different areas here which can help you. Workplace safety, wage and hours and leave, if you go to where the arrow that just popped up, the COVID-19 webpage, that will take you to a bunch of resources for employers and for workers around infection prevention information, all kinds of additional things around the leave laws and things that are available, as well as this link, which has all kinds of information, excuse me, on common issues that employers and workers face when responding to COVID-19. This is where all the FAQs and things are available. So if you click the first link, the COVID-19 webpage, it takes you here. I may have that backwards. The second link may take you here. One of those links takes you to the COVID-19 in the American workplace. And as you can see, there are a number of different resources on this page that are available to you. There is the information on the paid leave available under the Family First Coronavirus Relief Act or Response Act. It's the temporary rule. There are fact sheets. There is the employee paid leave rights. There is the paid leave requirements. And then there are the Q&A or the FAQs, questions and answers for employers and employees that you may need. And then there's also, I don't have the rest of the page showing because there wasn't enough space, but there's also a place where there are posters. So if you need them in other languages, you go to the links that are under the posters heading and you can find them there. If you click on, if you click on the first link, the COVID-19 webpage link, it's going to take you to this page. Which actually is a link to the OSHA, www.osha.gov. OSHA is the federal, as most of you know, the federal workplace safety organization that is in charge of setting standards nationwide. When you get to that page, it has all kinds of different things on the web page that are useful. I am going to take you to the area that is on the right where it says highlights. But these other areas have information that you as an employer can use, any news that's coming out for specific industries, hazard recognition, how to, information on how the disease spreads, things that you can give to your employees to train them, what the standards are that you have to meet for COVID-19 related issues. But I'm going to take you to industry guides, which are the links on the right side of that page. There are very specific industry guides under the federal OSHA standard. As you can see, there's some for nursing homes, for pharmacies, for rideshare workers, for dental practitioners, for restaurants, and there's also one for manufacturing. And I'm assuming that there are some of you on this webinar who are manufacturers of some aspect of the monuments. So this guidance would apply to you. And then the image on the right where it says COVID-19 guidance for the manufacturing industry workforce, this is what you get when you click on that link for manufacturing. You get this one-page flyer. There's also a bunch of other COVID-19 guidance, including if you have somebody who becomes ill with COVID-19 in your workplace, when you have to report that as an OSHA event, as a work-related injury event, and also whether or not it would be something that would qualify under your workers' comp carrier. In California, we have a presumption that COVID-19 cases for people who work outside of the home that have occurred, between a certain time period, that there's a presumption that it's COVID-19. But there's not a presumption that it has to be reported under OSHA unless it falls within the OSHA guidelines, the federal OSHA guidelines. So I would encourage you to look at not only when you have to report a COVID-19 illness in your workplace under OSHA, but I would also encourage you to look at your workers' comp situation in your state to determine if there is a first report of illness or injury that needs to be filed for a COVID-19 related illness.
And real quick question from Ann Minor here. I believe she's referring to what you were just referring to, and she says, will that be part of the package being sent after the webinar?
I did include the federal OSHA guidance on when to report a COVID-19 illness. I'm pretty sure that's one of the handouts that I put in the thing. And basically, what it says definitively is if you have a cluster in your workplace, under the federal OSHA guidelines. In other words, there's been an outbreak in your workplace, or if you are in an industry where people are constantly being exposed, if you're meat packers, if you're grocery stores, if you're healthcare workers, and there's a cluster, then it's a reportable incident under OSHA. Or if you have a reasonable belief that it was something that was spread in your workplace, then you should report it. But I believe that guidance is part of the handouts that I have provided. And if not, you can get it going back here. I think let's see. I think it's you can find it through this webpage. I think it's on this page somewhere where you can actually, under the standards. So if you look, I don't know if you guys can see my cursor where it says standards, new OSHA standards for COVID-19, enforcement discussion or discretion guidance, enforcement directives, and then I can't really read what that reads because the thing is over it. But I believe that the link is somewhere in this standards area, but it's definitely on the OSHA page for when you have to report it. Oh, here it is. And then they also have the worker exposure risk in Spanish, etc. So you can get these in multiple languages. Anyway, good question. Okay, so the other thing to note about these emergency bills, and I know we are almost 1 hour into this, so we're about to move to the next phase, which is the reopening phase. But I just will note that employees who are denied emergency FMLA or emergency sick leave do have the right to file a claim for the denial of that leave. They are encouraged, to contact their employer first. If you have fewer than 50 employees, they are required to report to the Department of Labor first. And there are different ways that they can report that, and they will accept those complaints and investigate them. If you have more than 50 employees, they can file a lawsuit against you directly without first going to the Department of Labor. It's just something to keep in mind. And I think we're going to see some of this coming up as things reopen, now that the shock is kind of wearing off and people are finding their new normal. So here's some of the questions that I typically get around these issues. So one of the first questions I get is, how do I integrate the emergency paid sick leave and emergency paid FMLA provisions with other forms of paid sick leave and regular FMLA? So it's really just an order of priorities. You assume the COVID-19 sick leave is in addition to any current program that you have at your workplace, and they are allowed to take the emergency sick leave and the emergency paid FMLA first before accessing their other sick leave, vacation, PTO, or other leave benefits. And again, the FMLA is capped at 12 weeks. Any restrictions that you have applicable to unlimited PTO programs should be communicated immediately. If you have an unlimited PTO program in your workplace, it's something that's very common in California, there's usually language in there stating whether or not a period of FMLA or California Family Rights Act or other protected leave, such as pregnancy, disability leave, will be included or excluded from that unlimited PTO program. Most employers, smaller employers, exclude protected leaves from unlimited PTO, although many of the larger tech employers do include it. So you should have a statement one way or another in your program. And of course, the employee can opt to use the emergency sick leave before the emergency FMLA. So it's really emergency sick leave, then emergency FMLA, and then any other accrued available leave that they have that would qualify. That's the order of priority. Some sort of practical questions. Can you ask an employee if they are sick when they're in the office? You can't just ask somebody, are you sick? But if you hear somebody coughing, or if you see somebody who looks like they have some symptoms, they're having difficulty breathing or something, you can ask them if they have COVID-19 symptoms. You have to limit it to the COVID-19 symptoms, or you can ask them if they were in contact with somebody who has COVID-19. But if they don't have any symptoms, you cannot ask the question. At least that's the guidance that we were giving at the beginning of this. Now in California, as things are reopening, a lot of the reopening guidance that they're giving out is to ask people, do you have any of these symptoms? So it's going to depend on what jurisdiction you're in as to what you can or cannot ask. In California, we tend to be very restrictive about what you can ask. You also have to be careful of the questions you ask in order not to be in violation of the Americans with Disabilities Act, where you are treating somebody as disabled or you are trying to pigeonhole or find out something about a disability. So you have to be careful around this, and I would look at local and state guidance for what you can or cannot do. Can you ask somebody what their symptoms are? Again, this is a California perspective. No, you cannot ask them a general question about their symptoms due to their medical privacy rights in California, but you can ask them a question such as if they have a respiratory disease. You also cannot ask them if they have a respiratory disease or are at risk, but if they're showing symptoms, you can ask them if they have a fever, you can ask them if they have shortness of breath, cough, aches, fatigue, etc. So again, in California, you can't ask about a specific disease, but you can ask about specific symptoms. And that's a good rule of thumb generally for employers elsewhere who may not have as strict privacy protections for employees in their state. But if you don't ask too many questions and you keep it focused on COVID-19 related issues, you are less likely to get into trouble. The other thing about this is you should have these conversations in a private place where your conversation cannot be overheard for a number of reasons. It's respectful of the employee, it prevents fear, it prevents rumors and gossip, etc. It's just really, a best practice. If an employee is to call in sick, what can you do? Can you ask them what their symptoms are? Yes, you can ask them if they are experiencing specific coronavirus symptoms such as fever, shortness of breath, cough, aches, fatigue, and some of the other symptoms that are coming out. You cannot ask them about any other symptoms that are not COVID-19 related. You can ask them if they are calling for their own situation or because a family member has a serious health condition that they need to attend to. In other words, is their kid sick? Is their parent sick? Is there another reason that's going to trigger an FMLA leave, whether it's an emergency FMLA leave or a regular unpaid FMLA leave? And again, I would encourage you to have that conversation in a private place. Can you conduct a health exam of an employee? Now, again, this is related to California specifically, and I would encourage you to look at your individual state's requirements. But generally speaking, even on a federal level, you typically cannot have a health exam of an employee without violating the ADA. But there is some guidance out right now that the EEOC has issued that says you can check for temperature. That is not going to be seen as a violation. Now, some of you may be thinking, what about, fitness for duty tests and hiring employees, et cetera. If that's something you've typically done as part of your employment process and you are hiring somebody new, you can continue to do that as part of your process, following your normal protocols. But if it's specific to COVID-19, it's really limited to asking a couple of questions and taking a temperature, and then, of course, not sharing that information with others, not spreading fear, etc. Okay, this is a question that's coming up a lot now that California and counties in California are starting to reopen, which is either my business is an essential business or I'm reopening and I have an employee who's not eligible for leave because they're not sick, they don't have a child that they're caring for, but they don't want to come back to work. Because they, for whatever reason, they don't want to come back. They're concerned. They want to continue to isolate and self-quarantine, and they are not able to telework in this particular job. And what can I, as an employer, do? This is the most common question I have been asked in the last week. I've probably answered it 20 times. First of all, assume that this individual does not have a medical condition that needs to be accommodated, because if they have a medical condition that needs to be accommodated, it's a different conversation where you may have to allow them to be out as an accommodation. And you go through the normal ADA process. But if it's not somebody who needs an accommodation and they don't qualify for leave, what can you do? Well, you can schedule them to show up to work and expect them to show up. And if they don't, you should let them know what the consequences are. You can still terminate an employee who refuses to come to work. It may seem harsh, but employers have, a business to run. And if they have employees who don't want to work and they don't have enough other employees who are willing and available to work and they need to fill that position, then an employer needs to do what an employer needs to do. Failure to work with no excused absence can be addressed as usual. but I would tell you, be consistent. If you're going to terminate one person for not coming in, then you can't let somebody else continue to be an employee who doesn't come in, because that can lead to problems. Unless you can justify it based on the nature of your operations, the nature of their role, or perhaps they have a disability, or they have somebody that they're caring for that they are concerned about taking the virus back to. If you're going to be making those kinds of determinations, you'd better be able to justify it, and you'd also better be able to demonstrate that that differentiation is not discriminatory in some way based on any protected category, because that's where you're going to get the challenges. So those are the most important or common questions. I also get a lot of questions about furloughed employees. Some people are like, what's a furlough? What's a layoff? A layoff is where you've terminated the employee from employment. A furlough is where the employee remains employed but is off work due to a closure or unavailability of work, or just you're suspending certain non-critical operations. The employee who is furloughed still receives employment benefits. Although if they're off for an extended period of time, they may be getting COBRA notification about their medical benefits. And what it does is it allows an employer to retain talent and bring their workforce back up to speed quickly when the need for the furlough ends. Whereas if you've terminated somebody through a layoff, they are no longer your employee. And you may try to recall them from layoff, but they don't have to come back because they're no longer your employee. Furloughs can be for a day, it can be for a week. It may involve rotating employees in and out of your workplace. But if you are furloughing or laying off employees, you should notify them of their status in writing, so that they know, I'm furloughed, I'm laid off. And if you know when they're going to return to work, then tell them, we believe we'll bring you back on X date, but if you can't promise it, don't promise it. Let them know that you will provide them an update as soon as you have it. And do stay in contact with them, because some employees will go find other work because they need to support their families. So one of the questions I get is, what impact does the COVID-19 requirements, emergency COVID-19 requirements, have on furloughed employees? Well, if they're still on the payroll, they have the right to take the leave if they meet the qualifications, but of course they're only going to get paid for the hours they would have been scheduled to work if they didn't take leave. So if it was a furlough week, they're not going to get paid for that week. So one of the other questions or some of the issues that I have seen come up with furloughed employees during this time period, there's a couple of what I call gotchas. If you have a furloughed worker and you haven't done furloughs before, or maybe you're just not sure of how things work. If you're in California and you furloughed somebody and it's lasting longer than 1 week or their pay period, then you have to pay out any accrued unused vacation, or else you are in violation of the wage and hour laws here. California is pretty picky. I don't know that any other states are that picky around furloughs, but I would encourage you to look at your jurisdiction if you have furloughed employees as to whether or not you need to pay that out. The other thing is, if you have any H-1B visa employees, which I have a lot of some of my tech clients, you've signed a contract with an H-1B visa employee, and you have to continue to pay them pursuant to the contract that you signed in connection with their visa, meaning if you're going to furlough them, you still have to pay them. Otherwise, you're in violation of your visa contract. So that's just something to be aware of. And then something that does apply, I think, to everybody here is if you have exempt employees and you're furloughing them, make sure you're furloughing them for the entire work week. Otherwise, you're going to owe them a full week's pay if they work 1 day that week, unless they're taking intermittent emergency FMLA or some other form of protected leave that's intermittent in basis. Okay, the other challenge that employers are facing right now is that the unemployment insurance benefit that's available due to the CARES Act is making it difficult for some employers to hire. And that's because the CARES Act provides for an additional $600 per week for any employee who's eligible for unemployment. So if the employee receives even $1 in unemployment from their state, they get an additional $600 a week, which is equivalent of a $15 an hour, 40-hour a week job. So for the employees who make minimum wage or below, it's better to be on unemployment than to be working, and that is making it hard for employers to get people to come and apply for jobs, or for people that they've laid off to recall them to work. One of the things that's happening as a result of this is I think Congress is starting to realize that not only do we have record unemployment, but we have a bunch of people who are better off on unemployment. Instead of it being a bridge to another job, to make ends meet. It's actually better than the job that they had. And so they don't want to go back to work. And so Congress is looking at maybe undoing some of the benefits available in terms of people have to go be out looking for work, et cetera. Unemployment benefits are only available to people who are out of work through no fault of their own, and they must be available to work. That is the norm under unemployment. With the CARES Act, they removed the available to and looking for work requirement, which is why this is such an issue. But if you do have somebody who quit without cause, who just failed to show up for work, they're not eligible for leave, they're not sick, etc., they're not caring for children, what have you, then they would not be eligible for unemployment. And anybody who does quit without cause in order to obtain the benefits through fraud will be ineligible for unemployment. They'll actually be investigated. They'll have to make restitution. They may be subject to criminal prosecution, and they'll have to repay any benefits that they received. And some states are putting hotlines into effect so that employers can call in and say, I've tried to get people to work, or I've tried to call this person to work, they're refusing to work, and then that basically sets out the unemployment department on an employee for not accepting work that's available. There are unemployment benefits for the traditionally ineligible. And those are independent contractors, self-employed. They're being administered through the state program. I'm not going to spend a lot of time on this because I think you can just read through the slides and it will give you the information as to how that is available. I know that some people have had questions about that because they've had contractors who've been affected. And then there's also some guidance on workplace safety. And I'm going to go through the guidance on workplace safety quickly because I want to get to the reopening slides as well. If you use respirators in your workplace, if you have PPE equipment that's required as part of your manufacturing processes, there have been a lot of changes to the guidance around the use of masks due to the unavailability of the masks. And I can basically sum up these next 3 or 4 slides in a couple of sentences. Basically, N95 masks are the first masks that should be used, the ones that have been approved for use in the US. There's limited use and reuse of those respirators. If somebody's reusing the respirator, it has to be the same person who used it initially. You should start with an N95 respirator that is not expired. But then if you don't have any that are unexpired, then you can use expired respirators as long as they are still in clean, safe working conditions and they are not being reused by somebody who is not the same person. Once you don't have any N95 respirators that are available that have been approved by the US, then you can look to N95 respirators that have been approved by other countries. With China being the last resort if it's been approved by China. So if you have something that's available from another country, such as Spain, England, someplace in Europe, or somewhere else in South America, wherever, you should use those N95 masks before you use N95 masks that meet the standards in China. So I would just encourage you to look at the guidance on the use of respirators and masks. And also a lot of local jurisdictions are requiring any kind of mask or face covering that's not an N95 for the public before they can go into certain places. And they are also encouraging employers to allow employees to bring their own masks if employers don't have them, and to wear them. And what I would say to that is you still have to make sure that it's safe. So if you have an employee who's wearing a bandana, for example, as a mask, and it dangles down below their chin, and they're working with machinery that has moving parts and stuff, and it can become caught in that would not be safe. Or if they're working with flammable materials and it could go up in flames, that's not safe. So you still have to make sure that it's clean and that it's safe and that it's not going to create a hazard in your workplace. So let's talk about reopening. We have about 15 minutes. And I will stay on at the end of the 90 minutes to answer any additional questions that come up. There has been announced a 3-stage reopening plan by the federal government. The ability to reopen is based on a downward trajectory of COVID-19 illnesses over a 14-day period, downward trajectory of both symptoms and positive tests, along with a robust testing program available and hospital capacity to treat patients with crisis care, without crisis care. States should also have the ability to test and contact trace quickly and efficiently, including people who are asymptomatic. They should have sufficient PPE on stand and critical medical equipment available with surge ICU capacity. And they should be able to protect the health and safety of workers in critical industries and high-risk facilities, as well as having expected protocols for social distancing and safety, sanitizing, etc. If there is a resurgence in the COVID-19 virus in certain areas who have started to reopen or a rebound in outbreaks, they're expected to scale back their reopening. The three-stage plan is as follows. Phase 1, continue to encourage telework whenever feasible, return to work in phases, close common areas where personnel will congregate and interact, enforce strict social distancing guidelines, minimize non-essential travel, follow the CDC guidelines regarding isolation following travel, and then strongly consider special accommodations for people who are at risk under the CDC guidance. Specific employers, such as schools and organized youth activities that were closed, have been told they should stay closed, and there should be certain restrictions on things like visiting senior centers, limiting large venues such as sit-down dining, movie theaters, gatherings, etc. Although they're saying that elective surgeries may resume, gyms may reopen with strict protocols, but bars should remain closed. Here's my slide on phase. I had a slide on phase 2. Phase 2 is basically reopening. It's probably, there it is. It's just out of order. Phase 2, continue to encourage telework whenever possible. Close common areas where personnel are likely to congregate or interact, or enforce social distancing protocols. Strongly consider, again, special accommodations for personnel who are vulnerable, and bars may operate with diminished standing room occupancy where applicable and appropriate. And then stage 3, resume unrestricted staffing. You're free to move about the country, to borrow a phrase from Southwest. Now, I will note that every state and local government has their own protocols. At least in California, every local government has their own protocol as well. So I would encourage you to look at what your state's plan is for reopening, because there's probably more specific guidance for you. And I'll give you an example of what California is doing on how to reopen safely. But it's in California, we have state guidance, we have county guidance, and in some cases we have city guidance. And so you have to comply with city, county, state, and federal guidance all at once in order to reopen. And I would just encourage you to look at what your jurisdiction requires, go to your government websites and find out what the protocols are. So for example, California has this thing called the Resilience Roadmap. And when you go look at the Resilience Roadmap, it has specific industry guidance for about 20 different industries. This is the industry guidance for retail. And so there's an overview, there's a purpose, there's a worksite specific plan. You have to do certain training for your employees. You have to have physical distancing guidelines in place. You have to have cleaning protocols, and then there's a checklist. And the checklist, you have to basically be able to go through and check off each of these items that you have completed it in order to reopen. So you have to have a worksite specific plan, you have to employee training, you have to have measures and screening for people with COVID-19, you have to have cleaning and disinfecting protocols, and you have to have physical distancing guidelines, and you have to check off that I've gone through all these different things. So your state, your local government may have something similar. So once, if you've been open the entire time, my advice is that you look at whatever your state and local government requirements are to make sure that you're meeting them. Because even though you may be an essential business that has not been closed down, you still want to make sure that you're taking the appropriate precautions and that you haven't been doing something that could be considered negligent that can lead to claims. So there may be some ideas in there that you haven't thought about that you can put into place to make your workplace more safe. The other thing is that if you have been running on limited operations or you've been closed down and you're now looking at reopening full operations, there's a lot to consider. And just because you can open doesn't mean that you should open. And the other piece of this is just because you've been able to stay open for a while, it doesn't mean it's been good for business for you. And so you need to have some strategic long-term planning, because it looks like we're going to be in this situation at least for a few more months and potentially into next year or beyond. We just don't know. I think we're going to reopen the country, and then I think we're going to have a boomerang effect, and you're going to see some opening and closing and sort of some back and forth potentially. And if that is the case, then you need to have that long-term planning. So you need to look at strategic business planning and cost reduction. What are your core business functions? Can you do work sharing? Are there wage cuts, voluntary time off with pay? How do you sort of economically plan? Is there a way that you can also increase your revenues, either through getting loans, bridge funding, CARES Act? There's another bill going through Congress. I don't know what's going to happen with that in terms of the Senate passing it and whether or not it's a good idea. That's a subject for another day. But you need to look at, how do I keep the capital coming in? And how do I remain viable as a business? How do I compete with unemployment? Do I have the ability to compete with unemployment? Do I have the ability to increase wages for those workers that I need to keep business going? You know, this is a big issue for employers. They're having a hard time getting staffing. And so those are some challenges that you're going to have to think through. I would also say probably the biggest concern right now that I have as an employer is not just the nuts and bolts of, am I providing leave or not providing leave, but how employers in trying to do the right thing and make sure that their workers are safe and their workers' families are safe are at times creating bias in the workplace that they don't even realize. So especially when this first came out, I was hearing a lot of people saying, well, I have an employee who's pregnant, I have an employee who's older, I have somebody who's got disability, such as diabetes or a heart condition, and they are in the at-risk category. I just want to send them home. I don't want them to be exposed. I'm really concerned for them. Well, guess what? By doing that, you are treating them as disabled. You are discriminating against them. You're treating, it's age discrimination. It's, you know, different forms of discrimination. So you need to be really careful about the types of things that you say and that your managers say. The other question that I'm getting around some of the reopening is, I've reopened. I have somebody who doesn't want to come in. What do? I think I've already addressed this question. You can terminate. You can switch them to another position. You can place them on paid leave. But if you have a bunch of people who feel the same way, you need to be careful because you've set a precedent. So think through any answers that you're going to give. And if the individual does have a disability, you do have to accommodate them. So if you are closed and thinking about reopening, what should you do? Well, I would say do an analysis, a business analysis, weigh the pros and cons of reopening, and determine whether or not you're ready or able to do so successfully. Not just financially successfully, but from a logistics standpoint. You have to do a financial analysis, profit and loss projections, payroll costs, supplies for cleaning, inventory and sales. Do you have the products that people need? Are you going to be able to maintain them given supply chain concerns? Do you need to find alternative avenues of supplies? Are you limited in what you can do? Do you have PPE that's needed? Do you have ways to take payment remotely? Do you need sneeze barriers if you're a retail outlet, etc.? Physical considerations. What does your physical space look like? Is there access to it? Does it need to be reconfigured or remodeled or marked for social distancing? Are there things that need to be delivered that can be done through contactless delivery or curbside pickup? Are you limiting the number of people who are in your space? Are you monitoring employee and customers for health and safety reasons? What protocols do you have in place? And then, of course, the personnel issues. Do you have a workforce? Do you have policies written? Have you trained your employees on the new protocols that are required from the CDC and from OSHA and from maybe state or local governments? How have you trained them? Have you documented that training? Do you have the workplace posters added to your workplace? All of these different things. And have you trained your managers on the emergency leave laws so that they know how to administer them? If you've been shut down, you need to think about things such as, who's going to administer this? How are we going to communicate it? Making sure that people know not to do the kind of things that I said about, bias and treating somebody as disabled or singling them out because of their age. Making sure that people are trained in how to diffuse tense situations. We've seen a number of issues in the last few weeks over an employee's arm was broken because they told somebody to wear a mask. Somebody else was shot and killed because they told somebody to wear a mask. People are not taking these situations well. They are behaving badly, and so you need to make sure that your employees know how to diffuse those tense situations and avoid that conflict or maintain safety. And then if your building has been closed for weeks or months, you need to do some things to make sure that it is physically safe. Has the water been standing? Do you need to flush the system? Is everything still in clean working order? Do you have a rodent problem? Those types of things, just make sure that you've thought a lot of that through. And then finally, what is your new normal going to look like in the short term and the long term? Is there, are there frequently used areas that need to be cleaned more frequently? Do you have people who are resistant to coming back into the office because they've been teleworking? What are you going to do about it? These are just all things you need to think through, essentially, as you are moving into this new phase. And I understand that this isn't a lot of legal content, but it is the practical things that I'm seeing my employers struggle with, as well as things like, how are you managing your headcount? Are you having people work remotely? Are you adding shifts so that you can have fewer people in the workplace? Are you staggering meal and rest breaks? Are you limiting travel? Do you have policies in place? Do you have vendor contracts that require certain things that you do in terms of working with business partners? Are you limiting who's in the building? Are you Zooming all the time? Those are essentially the things that you need to think about. And then back to your primary obligation, having a safe workplace, both physical and mental safety is important. Following the OSHA guidelines, following the PPE, maintaining a clean work environment, but also managing the employee mental health. Change is stressful. Do you have employee assistance programs? Do you have wellness programs? Are you doing things that are making sure that people are maintaining good mental health throughout this, and that they're not taking their frustrations out on each other? I think we're close to the end of the presentation here. My mantra the entire time is that leadership during this crisis is essential for your business, and for your family and friends. Making sure that you have open lines of communication, that you are letting people know what policies are changing, what you're doing to protect them, when they're going to be working, having people trained to answer questions and connect with employees with their resources that are available, being calm, being measured, taking self-care as well. All of those things are really important to getting through this in a good way. Here are some resources that are available to you as employers. These are also in the slide deck that is one of the handouts. But there's some great information out on websites that the government, a lot of these are state, California state, and then federal websites for resources available to employers. Pardon me. If I have questions, I'm happy to take them now. I think this is the end of the presentation. I actually brought it in right on time. So do we have any questions, Chip?
I don't see any in the chat. If anybody has any, now's a good opportunity to add chat, or if you have the ability to unmute yourself, you can verbally ask Ann a question or offer a comment. So we'll do the pregnant pause here for a moment. And if not, Ann, I will thank you for what has been an extremely substantive and thorough and wide-ranging presentation. Extremely helpful, I'm sure, for everybody who's been on the webinar and those who registered but weren't able to make it, and we'll get all the handouts as well as the recording. And for all of everyone's benefit, this has been recorded, as Ann mentioned at the top, so we'll provide you the link to that so you can refer back to it, and then all the material. And otherwise, again, I thank Scott Neal and Paradise Pictures for being the sponsor of the webinar, and appreciate, again, Ann, the presentation and everyone's participation.
Yeah, and hopefully I didn't overwhelm everybody. I know it's a lot to take in, but there's just, the stuff gets really complicated.
It does indeed that. So again, thank you all. Ann, thank you. Have a great day. And seeing the comment from Lynn, excellent, and thank you. And I echo that. So thank you, Ann.
Thank you.
All right.
Thank
Take care, everybody. Bye.